Thank
The
you very
hearings
much.
in the hearings in the matter of case number CFI 15/2019 before Justice Sir Jeremy Cooke. The claimant is a litigant person and the defendant is represented by HFW and the lead counsel is Stephen Doherty from the Outer Temples. Thank you.
Yes. Now, Mr. Abdelsalam, you're not represented by a lawyer.
Yes, I am. I'm a litigant in person at the moment.
Yes, that's what I understand. You're not currently represented. Well, I'm
No.
going to ask Mr. Doherty just to explain to me the current position before I hear what you have to say, so that I have some understanding of it. Mr. Doherty, there have been various problems about the e-registry being closed over the weekend. So I've only been looking at the papers briefly this morning. So I need to be brought a little bit up to date. I've had the chance quickly to look at some of the notes that have been prepared and an application you've made. So I've got some understanding of the history. But my last involvement in this particular matter was back in January 2022. As I read it on my own papers. So perhaps you could just indicate really what's the matters that I need to deal with today.
Yes, Your Honour. As you'll see, the broader background is a little bit complicated. It gives some background to some still the outstanding issues. The narrow points that one would normally expect to discuss at the PTR, there doesn't seem to be a huge range of disagreement between the parties. We had put in our estimates of trial length and an indicative trial timetable last week. The claimant has come back, and I think that broadly we're in agreement with what the trial is like to look like. Effectively, it will be 2 days,
Yes.
short openings, witnesses, probably a slightly longer period of time for closing, given that. So I don't think there are any particular issues there. There are obviously outstanding issues with what the parties are identifying as being the issues for trial, and you'll have seen that there have been to date some 6 iterations of particulars of claim, made both prior to and after a Court of Appeal decision, and that's really what the unless order application that was put in at the tail end of last week relates to, is to try and establish certainty for what the issues at trial are going to be. The other outstanding procedural points are an ongoing process for a detailed cost assessment, which has been filed. So that's in relation to orders upheld by the Court of Appeal, but previous cost orders made in the defendant's favour in relation to costs thrown away from the various amendments, costs of its immediate judgment application. That's outstanding. I understand that Mr. Abdelsalam is asking, or has asked, the registry for extensions to various deadlines. The most striking one, of course, being he's asked for the trial date to be put back to June, which, for what I hope are obvious reasons, the defendant opposes. The trial's been listed for quite some time. Mr. Abdelsalam's solicitors on record have been off the record since, I think, the 30th of January. So there's been a period of at least 2 months in which they could have been replaced. This, of course, is a employment claim under the old law. There are claims for penalties and so on, and those continue to accrue. So I think the prejudice really ought to be obvious as well. So we obviously maintain that the trial date needs to be held, and that any directions that are made need to be with a view to the efficient conduct of trial in April.
Yes. Well, let me ask you this in relation to the latter matter. From my limited reading this morning, there's been a great deal of toing and froing about amendment to the particulars of claim to conform to the Court of Appeal order and the relevant legislation. But as matters currently stand, on the current pleading, what are the particular heads of damage which are in issue?
Yes, bear with me. I'll need to open up the particulars of claim. I think that broadly speaking, I understand that the the heads are not necessarily changed by the amendments that have been made, or certainly not all of them. What the issue is that there have been various amendments made in the current iteration of the particulars of claim, many of which haven't been redlined, some of which are more than simply amendments to the old law. So the scope of the amendments you may have gathered from the papers permitted by the Court of Appeal were effectively Mr. Abdelsalam's claim previously made reference to various iterations of a 2018 draft employment law and the 2019 employment law. The Court of Appeal permitted the amendments to be made so that they would reflect the equivalent provisions in the 05 law and where applicable as amended by the 12 law. But the amendments that were subsequently made in iterations 5 and 6 of his particulars of claim went beyond the scope of those amendments. And that included following an order made by the registry following the Court of Appeal's judgment. So that was on the 20th of January 2022, which specified that any amendments falling within the scope of the Court of Appeal's order had to be identified in red line, and that anything falling outside that needed to be highlighted in green and accompanied by an application to amend if that's what was being sought. And of course, none of that's happened. So the issue is what needs to happen is the claimant needs to go back to his original particulars of claim, the very first version, amend that to replace any references to either the new or the draft 2018 employment law with amendments to the 2005 law and their comparable provisions, but to not make any amendments that fall outside that scope, and to not make any substantive changes to the pleading.
Yes. But as matters stand, Mr. Doherty, if I were to maintain the existing trial date, there'd actually be no practical difficulty in me determining the issues that fall to be decided. However, the pleading is framed in relation to the wrong bit of legislation. There's no real difficulty in identifying what the issues are as they stand on the pleadings, if the assumption is made that the correct piece of legislation is referred to.
Yes, I think really from the defendant's perspective, it's having clarity about which document effectively stands as the pleaded case.
I understand.
So my understanding, it would need to be the original pleading, updated with those provisions of law reflected. And I understand that Mr. Abdelsalam has suggested that he will make those amendments. I think he had suggested within 14 days. In my submission, given the trial date and given the relative straightforwardness of the amendments, we could do that in 7 days, and that would enable the defendant to maintain its application for an unless order in case we get another iteration that doesn't conform, but give sufficient time before trial to ensure that everything that needs to be prepared in time can be.
Yes. All right, Mr. Abdelsalam, what would you like to say?
Thank you very much, Your Honor. First of all, I would like to highlight the issue of the several amendments. I think since the third amendment, we refer to the law of 2005, amended as law of 2012. But the issues have been since then, mainly about the compliance to the orders in terms of highlighting colors in red and green, some RDCs, I think. So I'm not a lawyer, but I think most of the issues from my review are related to this part, not the law or the correct revisions and so on. In terms of the particulars of claim and the areas of dispute, the cause of action, I think they have been the same almost. There have been just minor changes. So the case stands, I think, clear in terms of what the dispute is about and which law and provisions that we rely on. I regret we know what happened, of course, for having these several amendments. I tried from the beginning to get a professional lawyer, and this is why from day when I got a firm registered in the DIFC portal, and then when I got some comments that the amendments were not in the proper way, and so I changed the firm. I went to another firm when I got where I got my previous counsel, who was supposed to present before the court in the trial. And then she moved to another firm. I moved again to that firm, which is also DIFC registered firm, qualified firm. And she submitted the latest versions of the POC. Unfortunately, due to health issues, she had to withdraw unexpectedly last week, end of last week. And she was supposed to attend the trial. This is why I was sure that we are going to meet the deadlines, but it's unexpected to have someone seriously ill in short notice. The point that has been highlighted by the defendant that I didn't have a firm representing me since end of January. That's true, because at that time, my counsel, Ms. Louise, left that firm. But I maintained her as my legal advisor, and I highlighted clearly to the court through an email sent to the registry that she will represent me in the trial. So for the trial, she was going to be there, and she was going to be my counsel. So I wasn't going to be a litigant in person for the trial. But just unfortunately, due to her sickness, I ended up now without representation for the trial, and this is why I thought, if it's possible, to get some extension. If not, I will still try to do my best. I've been working during the last 3 days, although it was a weekend, contacting several firms and councils and so on to try to get things in track during this limited time. I assume I might be able to do it, but I'm not sure. This is why I put the option of postponing the trial up to the early of June, not more than that. I think 3 or 4 weeks extra will make things perfect. Otherwise, I will try to work within the tight timelines. My main concern is to make sure that we reflect a proper documents, proper pleadings, to reflect to the court, the honorable court, the case, and all the cause of action and the legal grounds that we rely on, for the sake of justice and clarity.
Yes. All right. Well, I understand, Mr. Abdelsalam, but the position is this, that there's been a trial date fixed for a very long time now, and we need to stick to that trial date. As I understand sufficiently of the issues to know that as long as you do get some lawyers engaged, there's plenty of time for them to be ready for a trial. It's over a month away. The issues are not large. At the end of the day, the pleadings point is fairly easily resolved. So that ought not to be a real issue either. So I'm not going to adjourn the trial, and we just need to make some provision for what is to take place before then, either in the event that you do engage fresh lawyers or you appear as a litigant person, whichever it is. But the trial will go ahead one way or the other. What I think I would suggest is something like this. We need a period of about 7 days in which you can inform the defendant whether or not you've managed to obtain further legal representation, and then a further 7 days beyond that, in which there must be an amendment of the particulars of claim to accord with the judgment of the Court of Appeal. And beyond that, what more do we actually need, Mr. Doherty, in relation? We've got witness statements already and so on.
Yes, we have witness statements. They will need to have a trial, an agreed bundle. Trial index and bundle.
Well, Mr. Doherty, I'm inclined to think that the sensible and practical answer to that is for the defendants to prepare it. I know that's not the usual form, but given the potential difficulties about representation on Mr. Abdelsalam's side, it would be sensible for the defendants to take the burden of that. And on that basis, one could be very confident the trial will go ahead on the days in question, whatever happens. I mean, I'll be quite frank with you, Mr. Doherty, I'm not likely to want to strike out a claim on the basis of failures to properly plead it in accordance with the judgment of the Court of Appeal, whether it's in red, green, yellow, or any other colour, because I don't regard this as such a sufficiently difficult case that the pleading is in the end going to matter very much.
Yes and no. I think that the real sort of issue, or the real menace from our perspective, is understanding what we're going to be working off. So although the heads of claim don't change, there are substantive differences in pleading. So I've highlighted a number of the main ones in you'll find that they're in the exhibit that was attached to my PCR note, which included the application for the unless order. But there are arguments around statutory notice requirements and things like that that simply didn't appear in the originating pleading, nor did they appear within the scope of what was permitted by the Court of Appeal's amendments, which of course was just the inclusion of specific cross references to provisions of the old law. So if we go into the trial on the understanding that effectively what we're dealing with is the originating pleading with the amendments that fall within the scope of what the claimant actually applied to amend and those specific provisions of law, I think that one can see how we could proceed on that basis, but it's really just about being careful to pick out those arguments which are new substantive arguments.
I understand the need for clarity, but if there's to be an amendment that falls outside the ambit of what the Court of Appeal has specifically said, it will have to be an application for permission to amend, and we'll have to deal with it as and when it arises. But as matters stand, otherwise we proceed on the basis that we have a pleading, in effect, that does accord with it, with the Court of Appeal judgment, and that's the basis upon which you work. And
Yes,
if we have, if we know within 7 days whether or not there's going to be another firm of lawyers involved, and within 7 days thereafter there's any further, the further pleading is produced, if there's an application to amend because new substantive points want to be raised, well, we'll have to cross that bridge. Yeah. And maybe we'll have to deal with that at trial, and you'll have to be prepared for alternative ways of putting the case. But at the end of the day, it's not a hugely difficult case factually, and it's going to depend on the same witnesses and the same documents.
Yeah, I completely see the sense in all of that. It is a relatively straightforward case. I think we want to make sure it doesn't become more complicated than it needs to be because of the procedural history.
I understood, and I think Mr. Abdelsalam will be aware of that because he's conscious of the number of times amendments have sought to be made. Mr. Abdelsalam, you really do need to take every step you can to engage other lawyers. I appreciate that involves cost on your part, but I'm afraid that's the way litigation operates. So I'm going to give you 7 days to inform the other side whether or not you're going to engage new lawyers. Within 7 days after that, if you have engaged new lawyers, then they must comply with the order of the Court of Appeal to amend the particulars of claim in accordance with the Court of Appeal order. You understand?
Yeah, I do understand. Yes.
Good. I'm going to get asked that the defendants will prepare all the documents, the bundle of documents for trial, so you're relieved of that responsibility. But obviously,
thank you very much for that. Yeah.
But if you instruct lawyers and they want some additional documents in, then that's a matter for them, and they'll have to liaise with HFW to achieve that. And if they want to make any amendment beyond that which the Court of Appeal has allowed, they need to get on with it and make an application very quickly indeed. But I can tell you now, Mr. Abdelsalam, that I would be most unlikely to adjourn the trial in any circumstances because it's been outstanding for so long, and finality is important for you as well as
yes.
the other side. We want this matter to come to a close. All right. Now, is there anything else?
No, that's all. Yeah, it's my interest to have the case as soon as possible.
Yes,
But thank you
of
very much
course.
for that. Yeah, I will do all possible efforts to make sure that we meet everything on trial on time.
Yes. Yes, good. All right. Now, is there anything else that specifically needs to be ordered, Mr. Doherty?
I'm not sure. I'm slightly in your hands, Your Honour. There's a separate issue which relates to. I think Mr. Abdelsalam has asked for additional time, which has been resisted, to file points of dispute in relation to detailed cost assessment. I would assume that that's probably a matter that we need to pick up with the registry rather than with you, because it relates to costs at various different stages of the proceedings.
Yeah, I mean, the reality is the chances of all that being sorted out before you get to trial are minimal anyway, aren't they?
We'll see. I suppose it's a matter for the registry.
All right. Well, I've no idea what's it.
Yes,
I
figured that would be the case. Like,
I think the answer is to deal with the registry, and if there are matters that still need to be dealt with, we'll deal with them when we get to trial.
Yes.
All right. Now, Mr. Doherty, I'm going to ask you to draw up the order, please, as well. The order that I've made, and submit it to the court and to Mr. Abdelsalam, and I'll then approve it. Otherwise, I shall see you both on whatever date it is in May, 7th or 8th of May, is it?
8th of May, yeah.
The 8th of May, whenever it is. Yes, I've got the date in the diary, so I'll see you then. Nothing else then at this stage. We'll reserve costs of today, being a pre-trial review, and we'll see where we get to at trial. All right.
Yes.
All right. Thank you very much. Thank you, Your Honor.
If you'd both like to sign out, I'll just have a quick word with the associate, if I may.
Yeah, I will.
Thank you very much.
Thank you.
Thank you very much.